Hello, my name is Michael Tesoro and I prepared this video note on a couple of recent cases on legal professional privilege. A bit of background about myself. I'm a competition and consumer lawyer. Been running my own business, Tesoro Lee Consulting, for about 13 years now. Prior to that, I worked at the ACCC. I was a former Director of Enforcement and I had cause to run one legal professional privilege case when I was at the ACCC. That was the case against Coles and Woolworths in the Liquorland case, which went to the High Court, and unfortunately the ACCC went down 7-0 in that particular case. But these two recent cases are of particular interest, I think, and worthwhile having a look at. And the first case is TerraCom Ltd and ASIC, and that's a case involving waiver. And the second case is the Commissioner of Taxation and PricewaterhouseCoopers, and that's a case of whether privilege claims have been properly made. Now, the background to the TerraCom case is that ASIC commenced an investigation of suspected contraventions of the Corporations Act by both TerraCom and some of its employees, and it related to the testing and certification of and sale of coal during a particular period. Now, as part of that investigation, ASIC issued a warrant on TerraCom and it caught a document called the Project Rex report prepared by PwC, and that was seized by ASIC, but because there was a claim of privilege over the document, ASIC didn't look at what was in the document, and that led to the current litigation. Now, the background to the investigation is that effectively a former employee of TerraCom, Justin Williams, made some serious allegations about the company and the CFO and CEO, claiming that they'd falsified certificates for coal that was to be exported, claiming that the coal was of a higher grade than it actually was. But the second event, which also contributed to the ASIC investigation, was a disclosure by the auditors for TerraCom, EY, Ernst & Young, in March 2020. And they wrote to ASIC in compliance with obligations under the Section 311 of the Corporations Act to notify ASIC that they were aware of some circumstances which may amount to contravention of the Act. And that concern related to these particular certificates of the coal exports. So the first issue that the court had to look at is whether the relationship was such that there could be a valid claim of legal professional privilege, and the judge concluded that it was obvious that privilege attached to the PricewaterhouseCoopers report. The evidence was clear that Ashurst had been retained and sought a report from PricewaterhouseCoopers, which was to be used for the purposes of giving legal advice to TerraCom. So there's no doubt that that was a dominant purpose of the preparation of the report, was to provide legal advice to the client. But the real issue arose in relation to waiver. ASIC alleged that there were 3 events which constituted waiver, which meant that the PwC report had to be handed over to ASIC. There were 3 disclosures. First was to a company called Tenio. Then there was an open letter to shareholders in March 2020 and an ASX announcement in April 2020. Now, I think it's fair to say that the court concluded that Tenio disclosure was not a waiver. However, there was a view that the other 2 disclosures did constitute a waiver. And what the judge is saying here is that using the PwC report to effectively deny any wrongdoing by the company and by the CEO and the CFO was inconsistent with maintaining the privilege that attached to the report. They're obviously trying to use the report to deflect criticism from the business, and they were pointing to the fact that we had this independent forensic investigation conducted, and so the company is using the report for a forensic or commercial advantage. So if you try to use it for that particular advantage, you're not going to be able to maintain the privilege in the document. The other observations by the judge was that it wasn't like a slip of the tongue or an inadvertent comment. He concluded that the TerraCom statements were not casually made. They were part of a conscious and deliberate strategy to reassure the shareholders and the market and the regulators that there was no substance to these complaints. And it would be unfair, given that the report was being used by TerraCom for that purpose, to maintain the privilege and not allow ASIC to have a copy of it. He comments there that without giving access to the report to ASIC, ASIC will be unable to test the validity of the claims which TerraCom's made, and that would result in unfairness. So on that basis, the judge concluded that both the shareholder letter and the ASX announcement had been a waiver of privilege in the PwC report, and that it had to be open to being disclosed to ASIC. The question then was how much of the report had to be disclosed. And this is an interesting angle. Like, the judge wanted to examine the whole report to determine how much of the report had been effectively waived, and ASIC opposed that approach, which surprised me a bit. The judge decided that it was best to review the report and make form a view as to whether it should be disclosed and how much. He concluded that it wasn't practical to determine the extent to which the subject matter of the report had been waived without having a close look at it. And effectively, there was a risk that if only parts of the report were released to ASIC, that it would be incomplete and liable to misunderstand them. So he's noting the way the report's written, the way that different parts of the report are interrelated. So he concludes ultimately that the partial disclosure of the contents of the report would be quite misleading, and that as a result, the only fair outcome to impose in this particular case is to release the entire report to ASIC. Now, the second case involving PricewaterhouseCoopers was arising from an audit of a company called Flora Green by the Commissioner of Taxation in February 2019. And in the course of that audit, the Commissioner issued notices to produce to Flora Green, and the notices were issued both to PricewaterhouseCoopers and to Flora Green. Now, in response to the notice, the claim was made that 44,000 documents that were caught by the notice to produce were privileged, and the Commissioner took exception to 15,500 of those claims. So this case is really about those 15,500 documents and whether they were subject to a proper claim of privilege. Now, the Commissioner relied on three grounds to challenge the privilege claims. The first was a form of the engagement between the company and PricewaterhouseCoopers. He also looked at the substance of the arrangement, and then finally whether the particular documents in dispute were subject to a valid claim of legal professional privilege due to the fact they were brought about for the dominant purpose of providing legal advice. Now, the judge didn't agree with the first two arguments, believed that as a matter of form or substance, there was a possibility that there could be a relationship of lawyer and client between Flora and PwC, and there's no suggestion that that couldn't have arisen. There was legal practitioners working for PwC in the process of generating these particular documents. However, the question then arose as to whether the specific documents were subject to a valid claim. And in this regard, what's interesting is that the judge decided to review a number of documents. And to assist the judge in that process, there was a decision to appoint 3 barristers as amici to assist the judge in reviewing the documents, working out whether the dominant purpose of the document on its face was to provide legal advice and to advise the judge. So effectively, there was a decision initially to have 50 documents each, 50 by the Commissioner of Taxation and 50 by the parties, but it rose to 116 documents, and each of those documents was examined and decided whether there was a valid claim for privilege. And as you can see, the outcome of the investigation is pretty startling, because as you can see, out of the 116 documents, 49 of them were found to be privileged, 6 were partly privileged, and then 61 were not privileged at all. So 55% of the entire number of documents were found not to evidence a valid privilege claim. And as you can see, the judge commented at paragraph 23 that the communication did not satisfy the dominant purpose test, that there was not sufficient evidence to show that those documents, those 61 documents, were prepared for the dominant purpose of giving or receiving legal advice. But another very concerning aspect of this case is the process which led to the identification of the 116 documents. The Commissioner served a draft list of 50 sample documents in April 2021 and served it on JBS, and immediately JBS withdrew the claims of privilege over a number of those documents, which forced the Commissioner to go back and identify some more documents to make up the sample of 50. Again, that was served on JBS in May 2021, and JBS parties withdrew the claims of privilege over a bunch of those documents. The Commissioner went back a third time to try and identify 50 documents, so identified a few replacement documents and served that on JBS, and again they withdrew claims of privilege over a number of those documents. Then finally, in June 2021, the Commissioner was able to select 50 documents over which JBS did not want to withdraw the claims of privilege. That's like it took 4 attempts to find 50 documents which JBS were willing to agree were subject to a valid privilege claim. Now, one thing that happened early in 2021 was the ATO put out a proposal whereby privilege claims would have to be subject to verification. So effectively, a taxpayer would hire a lawyer to help them with their tax claim, and if privilege claims were made, the ATO wanted there to be an obligation for the taxpayer to hire a second lawyer to verify those claims. And obviously that's driven very much by concern amongst people at the ATO and the Commissioner that law firms are making claims for privilege in tax matters which aren't well made out. But after quite a lot of opposition and concern about this particular proposal, there was a replacement idea which was called the ATO Legal Professional Privilege Protocol, which was put out for comment in 2021. I think it closed in about September, October, and a lot of different groups put comments, including the Law Council of Australia. And effectively, it's a different way of approaching privilege claims in the taxation area. Obviously, a requirement that you assess your claims very carefully, but also you particularize your claims and you explain the basis of your claims. And finally, that you tell the ATO when you're making claims how you've used this particular protocol. So this is an idea that's been canvassed as a way of trying to ensure that only valid claims for privilege are made in tax matters. So it'll be interesting to see when a final version of this protocol comes out, obviously most likely after the election's been decided, and whether it comes out in the form that it was released or whether the ATO goes back to its previous position about getting a second lawyer to verify all privilege claims. There's a bit of quick commentary. Like, I'm not a tax expert and I'm not a corporations law expert, but I think the general principles here are clearly waiver, to be very careful if you get legal advice, not to comment about it publicly, and if you are going to comment on it publicly, be conscious that if you're doing it in a considered and premeditated manner, you're likely to lose privilege over that document. So you can't have your cake and eat it too. If you get some legal advice and you want to maintain privilege, then you can't be talking about it in public communications with your shareholders or with the market or even with the regulator. That's important. It's also important to make sure your reports are written in such a way that they may be more standalone sections, so that if you waive a particular part of the report, that the whole report isn't subject to being disclosed. So you may be mindful of cross-references in your report, so that if you disclose one aspect of the report, it doesn't mean that the whole report is liable to be handed over to the regulator. Another thing to be mindful of is that the court will look at the documents, despite what people say and the submissions which are made. The best way for a court to determine whether there's been a waiver or to determine whether there is a proper claim is to look at the documents. And the court will be willing to appoint barristers as amicus to assist in that process. So there's a lot of documents. It's not going to be, the court's not going to be overwhelmed by the size of the task. She'll be happy to appoint a number of barristers to assist in that role and to get advice from them as to what the documents say. And the final thing is just to ensure that proper claims are made. Like it is not possible to make claims with major regulators such as ASIC, the Tax Office, ACCC, and expect to get away with claims that aren't made for a proper purpose, because not only will the ATO and ASIC and ACCC push those matters all the way in the courts, but they know now that the judges will look at the claims and determine them. So if you make a problematic claim, then I think you're going to get caught out. So you've just got to be very careful to make claims that are well considered and valid. And I guess the final commentary here is whether this particular case involving PwC is going to give the ATO a further incentive to push for the changes which it initially wanted, which was effectively to get a second lawyer to verify the privilege claims of the first lawyer that the taxpayer is using, and whether if the ATO gets that particular power through whatever means, that whether other regulators will be pushing for a similar power. So there's a lot at stake here. It could result in, government being convinced that there's a real problem here with the privilege claims that are being made, and there needs to be this independent second legal advisor to verify that claims are being properly made. So we'll have to wait till after the election to see what happens there. So that's all I had. If you have any questions about the presentation, please feel free to give me a call or send me an email. Bye-bye.